This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about a pollution exclusion, eliminating coverage for a homeowners association sued by various neighbors. Because in Georgia, where the property was, stormwater is considered a pollutant, even if it is uncontaminated. It's just water coming from a storm and causing damage. Auto Owners Insurance Company versus Tabby Place Homeowners Association et al. On September 3, 2025, obtained a ruling from the United States District Court that there was no coverage for defense or indemnity. It is a judicial opinion on a declaratory judgment action involving Auto Owners Insurance Company and Tabby Place Homeowners Association and various property owners. The central issue concerned whether auto owners had a duty to defend or indemnify the homeowners association in an underlying lawsuit brought by property owners alleging property damage from stormwater flooding linked to the homeowners association's stormwater retention ponds. The underlying litigation involved property owners adjacent to Tabby Place and Captain's Cove Subdivisions on St. Simons Island, Georgia, alleging that the design, construction, and maintenance of stormwater retention ponds caused flooding and damage to their properties. The HOA acquired ownership of the retention ponds in September of 2020 after the property owners filed their initial lawsuit in 2019. Auto owners issued 2 insurance policies to the HOA in April of 2019, a commercial liability policy and a commercial umbrella policy, which are at issue in the declaratory judgment action. Auto owners sought a declaration that it had no duty to defend or indemnify the HOA based on policy exclusions, primarily the pollution exclusions, while the HOA and property owners contest that position. The CGL policy and umbrella policy provide coverage for property damage and personal injury, but contained exclusions, including pollution exclusions. Both policies exclude coverage for property damage arising from the discharge, dispersal, seepage, migration, release, or escape of pollutants, and the policies define pollutant broadly as any solid, liquid, gaseous, or thermal irritant or contaminant, including smoke, vapor, soot, fumes, acids, alkalis, chemicals, and waste. Auto owners contended that the stormwater flooding alleged in the underlying lawsuit qualifies as damage caused by pollutants under the pollution exclusions, thereby barring coverage. Auto owners also argued that the insurer's duty to defend is triggered only if the claims potentially fall within coverage, and here the pollution exclusions unambiguously apply. The primary legal question is whether stormwater, including stormwater infiltrating into groundwater, qualifies as a pollutant under the policy's pollution exclusions. The court reviewed relevant Georgia law and precedent, noting that the courts have consistently held that stormwater alone, even uncontaminated, constitutes a pollutant under similar insurance exclusions. The court rejected arguments that stormwater must be contaminated to qualify as a pollutant, or that rising groundwater is excluded from the pollution exclusion. The court further found no meaningful distinction between direct stormwater runoff and stormwater that infiltrates through the ground and raises groundwater levels, as both scenarios involve the discharge or migration of stormwater, which is a pollutant under the policies. The court cited multiple precedents from Georgia federal courts supporting this interpretation. 3 motions for summary judgment were before the court. The court applied the standard that summary judgment is appropriate if there is no genuine dispute of material fact. The moving party is entitled to judgment as a matter of law, and therefore the court concluded that the pollution exclusions unambiguously barred coverage for the property damage alleged in the underlying action because the damage arises from the discharge and migration of stormwater, which is a pollutant under Georgia law and the policy definitions, and as a result, auto owners had no duty to defend or indemnify the Homeowners Association. This ruling clarified the application of pollution exclusions and insurance policies to stormwater-related property damage claims under Georgia law, affirming that stormwater is considered a pollutant regardless of contamination or mode of discharge. In my opinion, as always, insurance is a contract. It defines the terms where it will respond with indemnity and the terms where it will not respond. In Georgia and in this policy, stormwater, even when it is not contaminated, is still a pollutant, and therefore the insurer neither owed defense nor indemnity to its insured. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,150 blog postings. You can also subscribe to these videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button on Rumble or the like button on YouTube. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. And please tell your friends and colleagues about this blog and these videos so that they too can subscribe. Thank you for your attention.